So the Supreme Court recently issued an 8-1 decision, which is now impacting the issue of concealed carry bans, which were once again pending in front of the Supreme Court and have now been sent down. Now, real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee, and they are huge Second Amendment supporters. They have dedicated roasts for organizations like FBC, GOA, SAF, and others. So if you want to get amazing coffee and support the 2A cause, check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. Now, like I mentioned in the intro, in this video, we need to talk about the recent Supreme Court 8-1 decision and how that's impacting the issue of concealed carry. You may recall that there were multiple cases that prior have gone up to the Supreme Court, one of them being recently the issue of New York in their Concealed Carry Improvement Act, and how states like New York, just 8 days after Bruen, passed new laws in direct defiance to what the Supreme Court said in Bruen. Recently, in that case, the Antonyuk case, the plaintiffs there went back up to the Supreme Court once again on an emergency basis and were seeking Supreme Court review and seeking for them to enforce Bruen against the new CCIA law and strike down that law. New York and the Second Circuit continue to defy the express language in Heller, McDonald, and Bruen, and also they are just outright defying the Second Amendment. And so that led GOA in the Antonyuk case to go up to Supreme Court seeking intervention at that time. But that case was put on hold behind the Rahimi case, and we received that 8-1 decision in Rahimi. The question was what would happen, and ultimately what ended up happening is the Supreme Court GVR'd, which means they granted, vacated, and remanded the Antonyuk case back down to the Second Circuit to re-review, reanalyze the case in light of Rahimi. And a lot of people have questions about what this means and what's going to happen going forward, so we need to break this down. Now, you may recall that in Bruen, the Supreme Court struck down New York's original May issue licensing scheme, finding that it was inconsistent with this nation's history and tradition. Now, one of the primary findings of Bruen in that decision was essentially that the government bears a burden to prove that their restrictions are based in the history and tradition of our nation, and essentially that evidence needs to date back to 1791. Now, another important thing that the Supreme Court did in that opinion in Bruen was that they stated that a state like New York could not simply make everywhere a sensitive location. They could not just make the entire island of Manhattan a sensitive location or a gun-free zone and therefore ban carry. However, despite that decision, New York rushed through the Concealed Carry Improvement Act, which was a permit scheme even worse than the one that existed prior to Bruen. Now, this law was challenged in multiple cases, and multiple district courts granted preliminary injunctions, halting the enforcement of the CCIA. However, the state of New York appealed those decisions up to the Second Circuit, who then granted blanket stays on those decisions. So there were preliminary injunctions that were put in place, which would have halted the application of the CCIA, but then the Second Circuit just blanket put a stay on all of those. Now, in response to that, originally GOA in the Antonyuk case sought emergency review from the Supreme Court, and that was the first emergency application. But then the Supreme Court denied that emergency application. This happened last year. And there was some language from Justice Alito essentially saying that, the Second Circuit would need to not drag this out. They need to at least identify why they're issuing these blanket stays, or they needed to expedite the hearings in those cases. Now, the Second Circuit decided to simply just expedite all those cases. They were consolidated, and then there was an expedited hearing on all the CCIA cases. Now, recently, the Second Circuit held those hearings, and they issued their ruling on 5 of those CCIA cases, and this happened back in last December. The big argument really came in the Antonyuk case, which was argued by GOA, and Antonyuk is one of those cases that deals with a lot of aspects of the CCIA. It deals with the permit process, it deals with the sensitive location bans, the specific locations like parks and places like that, but then also the catch-all provisions where you would have to get the affirmative permission from a business owner to carry at that location, or maybe signs would need to be put out. Now, one of the really interesting things with the Second Circuit's decision in all these CCIA cases is that in their decision, the Second Circuit tried to distinguish Bruen as an exceptional case. Now, the Second Circuit vacated a lot of the district court's preliminary injunction, finding that virtually almost all the CCIA is in fact facially constitutional under the Second Amendment. Now, the only thing that they found suspect and that they allowed a preliminary injunction to be put in place on was that catch-all provision where you would have to get permission. They said that that is potentially unconstitutional, so the preliminary injunction on that aspect was allowed to remain in place. But again, the Second Circuit's rationale was that somehow Bruen was an exceptional case, it was an exceptional issue, and that this issue here in Antonyuk and the whole CCIA laws are not exceptional and therefore Bruen doesn't apply. Now, in response to that Second Circuit ruling, GOA then filed a petition to the Supreme Court once again, seeking for the Supreme Court to step in at an interlocutory posture and override what the Second Circuit said. So again, this is not a final merits case. A final judgment has not been issued on this case. This is all dealing with a preliminary injunction, which was aiming to, at the initial stage, stop the CCIA from going into effect. Now, while all that was going on, there were other cases like the Rahimi case that were granted review from the Supreme Court that dealt with a different issue, that dealt with the federal bans on the possession of firearms, ammunition, the purchase and acquisition of, certain arms by people who are subject to domestic violence restraining orders. That was the Rahimi case. It was granted review by the Supreme Court, and then recently it was decided. And it was an 8-1 decision upholding that federal ban. It was in some ways a narrow decision, but then there was some analysis that went on there that could change some things going forward. Now, Antonyuk was put on hold behind Rahimi, and we were all wondering what was going to happen. What was the Supreme Court going to do? Because it kept getting rescheduled, and then it, went to conference and then wasn't rescheduled, but we also didn't have a denial. So what ended up happening is we got an order list after the Rahimi decision, and in the order list, what the Supreme Court has decided to do is GVR the Antonyuk case. They decided to grant, vacate, and remand Antonyuk back down to the Second Circuit and the lower courts to reanalyze this issue in light of Rahimi. Now, the big elephant in the room is what in Rahimi does the Supreme Court really think is going to change the outcome of the Antonyuk case? A lot of people, in my opinion also, is that this is simply the Supreme Court punting this issue, that they don't want to address this right now. Of course, they don't like interlocutory cases, but I think it's even bigger than that. I just don't think that they want to address this issue right now. But I think also maybe in some ways they're wanting the lower courts to further grapple with Bruen, and then also Rahimi with some of the how and why analysis in the relevantly similar issue. And I know this is getting a lot into the legal weeds, but just understand under Bruen, there was that specific analysis where you would have to look at the regulation from the government under the text of the Second Amendment as informed by relevant history and tradition. Now the Supreme Court is saying in Rahimi that it's the similar analysis. In some ways, people are saying that this has been the analysis all along under Bruen, but there was some debate in the lower courts. Some lower courts wanted a very narrow approach and application of Bruen, and that's what Justice Thomas also advocated for in his dissent in the Rahimi case. He was the only dissenter in Rahimi, saying that Bruen should be understood in a very narrow context, that the government needs to put forward a regulation or some sort of historical evidence, a single one that is relevantly similar in some way to justify their modern restriction. So he wanted a more narrow, restrictive approach, and then you had the majority in Rahimi that said, no, that's not how you should read Bruen. Now the government can put forward multiple justifications to meet the how and why question. They can put forward multiple evidence and kind of pick, the principles from this one, pick the principles from this one, and then put it together and say, okay, the general principle, and in 1791 that our founders believed in regards to the Second Amendment met this principle, and therefore we're going to apply this to the modern restriction. So you can see how there's this legal back and forth that's going on, different analysis approach, and maybe that's why the Supreme Court wanted to send this back down to the Second Circuit, because first and foremost, in the Antonyuk case, the Second Circuit believed that Bruen didn't apply at all. So here, what the Supreme Court would be signaling, saying, look at the Antonyuk case in light of Rahimi, is that, of course, Rahimi and Bruen and that analysis does apply here. So you can't just say that the CCIA doesn't apply when it comes to Bruen, that Bruen was an exceptional case. Here you have a direct command from the Supreme Court to reanalyze this case in light of the Rahimi and that analysis. I think ultimately the Second Circuit is going to rule the way that they want. I don't think that this is going to change the outcome of what the Second Circuit said. The silver lining with all this is still the preliminary injunction is in place when it comes to the catch-all provisions with sensitive locations. That's going to remain in place likely. But I think this is just kicking the can down the road. So hopefully that gives you guys some better understanding about what is going on right now with the fallout after the Rahimi decision and after all these GVRs of the cases that were pending. Also mention that we are doing a newsletter here on the channel. You can sign up using the links down below in the detail section and then also in the pinned comment. The newsletter, the main goal, of course, is just to have access to you guys, because a lot of the censorship that goes on online here on YouTube and other sites. And then one of the other things we're going to be doing is a monthly giveaway on the newsletter. So if you're a subscriber to the newsletter, you are automatically entered. And it's just one of those really cool things where I can communicate with you guys and then also do some things that we can't do here on the main channel. So again, if you want to sign up, if you want to support the newsletter, links will be down below. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.